Based on the petition and writ, which I believe have to be taken together under the rules of civil procedure, and the answer, without reference to any supplemental pleadings that were filed, or and based on the case law that I have read, and not relying on the last comments of Ms. Yohalem, I'm going to make the writ permanent. It's my opinion that the writ and petition are sufficient to establish the facts that are needed to show that what the writ is about, and to enable the respondent to answer, and to support the granting of a mandamus. To the extent that there is a conflict between the statutory criteria and the rules, I agree with the petitioners that the rules govern the pleadings in this case. And the petition and writ taken together are sufficient under the rules of pleading. I do not believe that the petition and the writ need to have the enrolled and engrossed bills attached to them. I believe that under the case law, not only the Kelly case, but that cockfighting case, it is sufficient if the two officers of the chambers of the legislature verify the petition and they allege that the bills were duly passed. And they have listed out the bills that are at issue. If I issue a writ of mandamus directed to the Secretary of State telling her that those particular bills should be considered law, there's going to be no problem getting the enrolled and engrossed copies of the bills over to her. She might even still have them, for all I know. In any event, I do not believe that that is an impediment to granting the writ. Now, I think with that, I'm going to get to the merits of the matter. Well, before I do that, let me just say, to the extent that there were any other procedural arguments that I will have overlooked by the time I'm done talking, I find them not to be persuasive either. So, first of all, I do want to point out that, to me, the case law that was presented shows that this court should not look into the content of the governor's veto message. And to the extent that the petition is read as challenging the content, I am not granting that portion of the petition. However, I would note that the petitioners withdrew any such challenge, which is good because it's not well taken. As to the Constitution itself, let me find my piece of paper. Section 22 of Article 4 has to be read as a whole, in my opinion. I think that it is a general, if not overarching principle, that you don't read provisions in isolation. You have to read them as a whole. And to me, this section sets up a procedure which is mandatory and which must be followed. And when the governor does not approve a bill, in the language of the Constitution, changing only the genders, she shall return it to the House in which it originated with her objections, which shall be entered at large upon the journal. So you need to have the returned bill with the objections, meaning they have to come together because it's the objections that are entered upon the journal. Then that third sentence says, any bill not returned by the governor within 3 days, Sundays excepted, after being presented to her, shall become a law, whether signed by him or not, unless there's an adjournment. So that sentence refers to a bill returned. What is a bill returned? It is what's referenced in the first sentence, when the governor is to return it to the House in which it originated with his objections. So the return involves both the bill and the objections, and I agree, given the short time period in which our legislature sits, and given the, with all due respect to the members of the legislature who are here, chaotic nature of the process, it is important that this provision be strictly construed so that the orderly business of both chambers of the legislature can take place. And you know the reason, they know the reasons for the governor's decision not to sign the bill, and they can act on those reasons upon the return of the bill with the objections. And I think that the vast bulk of the case law that was cited to me does stand for the proposition that those procedures are to be strictly construed and they must be strictly followed. Not only our own case of Wood, but other cases have also said that. And as to the Colorado interrogatories case that starts on page 216, I have to say that, since it's not binding on me, I actually found Justice Erickson's opinion to be more persuasive. And he said that the majority did not recognize the clear mandate of our Constitution. Vetoes which fail to comply with the letter of our Constitution are upheld solely on the ground that the legislature has somehow ratified the governor's constitutionally infirm vetoes by attempting to override them. The Constitution, however, requires only a majority legislative vote in the absence of a valid gubernatorial veto. If the governor fails to comply with the letter of our Constitution's veto provisions, the legislative acts become law in the same manner as if the governor had signed them. And while I agree with Mr. Kennedy, I think the effect of that interrogatories case was to allow for substantial compliance. I don't believe our Constitution contemplates substantial compliance, and I'm not going to adopt the reasoning of the majority of the court in re interrogatories of Colorado Senate of 51st General Session 578 P. 2nd 216. as I think I've already addressed this implicitly, but in case I did not, I do think that as to those 5 bills where the governor's message did not come down within the time frame contemplated by the Constitution, there is not any question but what those laws, her message did not come down within the time limit. Those laws became law because there was an improper veto. As to the laws where the message came down within the time limit, I still, because I am strictly applying Article 4, Section 22, believe that those laws those bills also became law because the objection was not sent back to the originating body of the legislature with the veto. And I believe they have to go together at the same time. And I do not believe that the doctrine of substantial compliance applies. I also think under the case law that has been cited that because there is this need for strict compliance, the asserted defenses of latches, acquiescence, and substantial compliance simply, as a matter of law, do not apply, and it is not necessary for me to hold an evidentiary hearing on any of those defenses. Finally, I do not believe that the issue of whether or not 2 of the laws are in conflict is in front of me. I don't think it needs to be. I don't believe this is the appropriate time for that issue to be decided. The Secretary of State will be given the copies of all of these bills that are listed in the petition. She will do what she does with those bills, and then the Compilation Commission will deal with that, and if somebody disagrees or thinks there's a conflict, I'm sure they'll think of a correct time in which to raise it. Probably some hemp grower who either wants or doesn't want to go to a particular regulatory body. I don't know. I really did not concern myself with the merits of the laws in making this decision. I don't think that is in front of me. That'll be up to some other person, body, group at a future date. So for those reasons, I'm making the writ permanent. I expect the petitioners to draft permanent writ of mandamus. I would like you to circulate it to Mr. Kennedy for any suggestions he may have, or to see if he can approve it as to form.